To begin.
Okay.
Good morning, good afternoon, sorry about that. Welcome to the third webinar in the child custody series, issues today dealing with issues of drug and alcohol abuse in child custody litigation. And we are honored today to have a special guest, Steve Paymer from Paymer Associates. Before we begin, let me just tell you what each of us will be talking about. Shane Duffy will be discussing what we do if our client is the substance abuser. Maxine Donskoy will be discussing if the other side or the other party is the substance abuse abuser. And Merrill Haif will be discussing evidentiary issues and how to make presentations of these issues in court. I will be interviewing Mr. Paymer and asking him a series of questions regarding his work, his experiences, and more specifics about what someone can do. As always in these webinars, the opinions that we give are our own. The experiences that we refer to are our own actual experiences in court. And so without further ado, we'll begin with Mr. Shane Duffy.
Good afternoon, everybody. My name is Shane Duffy, and I'm an associate attorney here at Fersch LLC. And I'm going to be discussing with you what we do and how we approach a situation when our client has a substance abuse issue. So the first step to addressing any substance abuse issue is realizing that there is an issue, whether the client makes it clear to us that they suspect there's an issue, or we pick up on it, or the other party alleges that they may have a substance abuse issue or an alcohol issue. So in order to understand a little bit more what we're talking about, I'm going to go through the DSM-5 definitions and criteria of alcohol use disorder and substance abuse disorder. So in the DSM-4, they used to define it as two separate orders. It was alcohol abuse and alcohol dependence. And now we're going to go over alcohol use disorder, which encapsulates both. So the formal definition is alcohol use disorder is defined as a problematic pattern of alcohol use leading to clinically significant impairment or distress as manifested by at least two of the following criteria over the same 12-month period. So I'll briefly go through the criteria here. And before we do, keep in mind the way that they grade the severity of the disorder is on the amount of symptoms present. So if there's 2 to 3 criteria that are met, it's considered a mild use disorder. When 4 or 5 are present, it's a moderate alcohol use disorder. And anything over 6 is considered severe. So with that in mind, we'll go through the symptoms. Alcohol used in larger amounts or over a longer period of time than intended. Persistent desire or unsuccessful attempts to cut down or control alcohol use. Significant time spent obtaining, using, and recovering from the effects of alcohol. Craving to use alcohol. Recurrent alcohol use leading to failure to fulfill major job role obligations at work, school, or home. Recurring use of alcohol despite having persistent or recurring social or interpersonal problems caused or worsened by alcohol use. Giving up or missing important social, occupational, or recreational activities due to alcohol use. Recurrent alcohol use in hazardous situations. And then markedly high tolerance and withdrawal symptoms, which I believe Mr. Paymer might touch on a little bit later. Next, we'll go over the DSM-5 definition for substance abuse. I'm not going to go through all the criteria like I did for alcohol use disorder because they mirror a lot of the same symptoms. But the substance abuse definition in the DSM-5 is a maladaptive pattern of substance use manifested by recurrent and significant adverse consequences related to the repeated use of substances. Also at this time, just want to remind everybody that this presentation, this webinar will be up on our website. And the slides will also be uploaded to our Instagram, Fersch Family Law LLC on Instagram, in case you can't catch all this information, because it is a lot. Next, I'm going to speak briefly on the importance of seeking treatment. Actually, I'm going to backtrack for one more moment just to touch on one last thing for substance abuse. So the substances that are under the umbrella of this definition are caffeine, cannabis, hallucinogens, inhalants, opioids, sedatives, hypnotics, stimulants, tobacco, and alcohol. Now I'll discuss the importance of treatment. So we counsel all of our clients to seek treatment immediately, whether it's an alcohol or narcotic addiction or some other substance. The sooner and the more thoroughly they address the issue of the substance abuse, the better. And then to the extent that the client is willing to enroll in some sort of cognitive therapy or pursue cognitive therapy to address the underlying causes of any substance abuse, it should be with a professional that specializes in addiction therapy. So next, I'm going to touch on some resources for those that clients we might direct to seek treatment. There's the Hazelden Betty Ford Center. It's a treatment center with 2 locations in Manhattan. I believe the main one is in Chelsea. It's an outpatient treatment center, and they tailor each person's treatment to their needs. And for a lot of people, they will counsel them they actually have mental health professionals in-house that will help address some of the underlying issues that cause substance abuse, such as anxiety or depression. If financial resources are limited, there's always Alcoholics Anonymous. Their website is here on the slide, and Narcotics Anonymous. Both are free, and most importantly, can be started by anyone at any time. At this time, I'm going to turn the presentation over to one of our partners here, Ms. Maxine Donskoy, and today she's going to discuss with you what happens when the other party is an abuser of drugs or alcohol. Thank you.
Thank you, Shane, and good afternoon, everyone. It is well settled that parties to a contested custody proceeding place their physical and mental conditions at issue. So if there are allegations of illicit drug use and/or alcohol abuse, they are taken extremely seriously. A court may refuse to grant overnight parenting time. They may even suspend parenting time altogether, or they may require supervised visitation. So, if you are aware of illicit drug use or alcohol abuse by the other party, and such use or misuse impacts a child or presents a risk of harm, there are serious decisions that need to be made to ensure that the child is safe and that the child's well-being is taken into account. Because impairment caused by voluntary drug use, prescription misuse, which is also difficult to prove, or alcohol abuse is considered neglect of a child. And if you knowingly place a child in the care and custody of another party who has such substance abuse issues, that can place the child in imminent danger by failing to provide proper supervision. So at this time, you may be thinking, what do I do? Well, it's not enough to just accuse someone of such abuse. There needs to be some sort of proof or evidence. And Meryl Haft will be discussing these evidentiary issues and how to get this sort of proof or evidence in her topic. So she will discuss that. But what you can do is you can provide proof, meaning if you have photos or text messages or videos of such, or have a private investigator. But the most solid proof would be having the other parent take a drug and or alcohol test. And there are several ways you can go about doing this. You can either do so by entering into an agreement between counsel that the party be drug and or alcohol tested. The only issue with this is that there needs to be consent. And I'm not sure that each and every time a party is willing to consent to such a test. So if there's no agreement, you would need to seek a court order. And you would be doing this by order to show cause or a notice of motion. You should be specific as to what substances the other party should be tested for in both your stipulation, if there's an agreement to testing, or in your order to show cause or motion, because there are different testing methods and different drug panels for these different substances. But you should also be aware that once you raise this, the other side may retaliate and then also request that you be drug and or alcohol tested. So this is something you should really be aware of and prepared for. So as I mentioned, there are different testing methods, and they are used to screen for illicit drug use, prescription drug use, or alcohol abuse. The different methods are usually conducted by taking samples of urine, hair, blood. It could be oral fluid, sweat testing, which our guest speaker, Mr. Steve Paymer, will be discussing, or even remote breath testing, which Mr. Steve Paymer will discuss further as well. But urine and hair drug tests are most commonly used by courts in custody matters where drug usage is at issue. Pre-COVID, you could even have a party take a urine test at the courthouse. I'm not sure what it's like now given the pandemic, but it's possible that in the future they will be doing that again. There are different detection times, and the detection times for most drugs will vary, and it varies based on different factors such as the type of drug use, the amount used, the potency of the drug, the individual's body type, health conditions, metabolism, exercise, and even water intake. And I'll discuss what's in a real life case, what some people do to try to dilute these samples, but that'll be in a little bit. Urine testing. A urine test is the most common form of drug testing, as previously mentioned, and a urine test can show traces of drug use even after the effects of the drug has worn off. The average detection time for drug testing via urine is 1 to 3 days and can be up to 90 days from last use for an individual using marijuana on a daily basis. And marijuana has the longest detection period. The amount of alcohol in a person's urine is usually greater than the amount of alcohol in their bloodstream. A urine test for ETG can detect alcohol ingestion for up to 80 hours. Then there is hair testing. Hair tests provide an extended detection window for drugs and an increased level of difficulty to contaminate a sample. So I think it's very important to ask for hair testing in your order or in your agreement, because hair tests will show drug use from approximately a week and up to 90 days of last use of an illicit substance. 1 centimeter of hair can reflect 1 month of drug use. On the screen, you'll see various drug screen panels. As you can see, they range from 5-panel to 12-panel. I'm not going to go through each and every one, but we can provide this, as Mr. Duffy mentioned, on our Instagram page. And if anybody emails me and would like a copy of the slides, I'd be happy to send them over. So I'll leave this up for just a little bit. So you have the agreement or the court order that the other party take the drug test or alcohol test. But what happens if the other party doesn't take it or tries to avoid it or makes excuses? Well, the court is permitted to make a negative inference and conclude what the results of the test may be. It could be that one party thinks it's a strategy to avoid the test, that it's better that the court take a negative inference because what they originally were being tested for, they're doing something worse. But really, the courts are aware of what's happening, and they can and they probably will make a negative inference, and it will not be positive for the other side. Avoiding the test. And here are some real life examples from cases that we actually litigated. There was an opposing party who knew that he had to take a drug test, and he had very dark brown hair, close to black, and on the day of the drug test, he came with very short shaved hair and it was bleach dyed blonde. The court was aware of what he was trying to do. There was a party who decided to shave all of his hair, not only on his head, but all through his body as well, and even cut his fingernails, so that way they cannot take any samples from the body or from the hair, because the hair samples don't have to just be taken from the head. They could be taken from other parts of the body. There's an example, this is also a real life case where somebody decided to strap urine to his body, a litigant, and come to family court because he knew that he would be subject to a urine test that day. So he strapped urine, I don't know where the sample was from, but the court officer obtained it when he was going through security. Then there's another case where a woman was told to take a urine test in family court as well. And she decided to drink excessive amounts of water to try to dilute the sample. Well, it turns out that she was not successful in diluting the sample and she tested positive, but she was also going to the bathroom every so often that the court noticed that there was something off there. There are also excuses that people take. Oh, I missed the test, I can't take it. Well, no, I did not drink alcohol. It was actually Listerine, the alcohol content in the Listerine, or the kombucha tea that I drank. And again, these are real excuses that people have made. These excuses don't really stick. And as I said, the court is permitted to make a negative inference and conclude what the results of the test are. But what happens if another party takes a test and they pass a test? Well, that's, the courts do promote that the children have a relationship with both parents, and that's very important. But even if someone passes a drug test or alcohol test, he or she may be subject to random testing if he or she has a history of such substance abuse and or misuse. So if there's a concern, even though a party does pass a test, and there is a concern because there are children involved and you want the custody and parenting time to continue, Mr. Paymer's company, which Ms. Fersch will be discussing with him in detail, provides services and tools for monitoring and random testing. So that'll be something interesting for you to hear, and options. I must tell you now that we will be answering some questions at the end of our webinar. Please do put those questions in our Q&A box, not in the chat box. If they are in the Q&A box, they are completely anonymous, and we will do our best to answer each and every question, as will Mr. Paymer. And at this time, I welcome Merrill Haft, who will be discussing evidence of substance abuse. Thank you so much.
Good afternoon. Thank you for joining us today. I am going to discuss how to prove there's a substance abuse problem, or how to prove the absence of one. So as Maxine Donskoy already mentioned, a party to custody litigation places their health and fitness at issue. So normally the starting point, if you suspect a substance abuse issue, would be to ask the other party to sign a HIPAA release and to try to obtain the necessary records from the physician of that party, or other medical records, to try to see if there's evidence of a problem. If the party will not consent, you may have to engage in motion practice, which has to be on notice to the institutions from which you seek the records. I will say that the providers can object, and they often do, on the basis of patient doctor privilege. We've had facilities refuse to disclose records of treatment on that basis, but you can seek a court order that those providers disclose the information. Prescription records may be relevant. You may want to try to subpoena a pharmacy to see if someone has, for example, taken Suboxone, which is used to treat alcohol dependency. You may want to see if someone has a prescription history for opioids, for example, which may have led to abuse. Therapist notes is another possibility. May contain details about the abuse or the dependency problem. Treatment at a hospital or facility. So if someone has sought treatment, there can be evidence in the facility records, for example, at Hazelden or other facilities that have already been mentioned, may contain a diagnosis of a party. And it may be helpful if there's a past history of an abuse issue which has been treated. You may want to disclose treatment records to show compliance, to show the other party, to show the court that you followed through with all the protocols. Most commonly, we start with evidence from our client. This could be photographs that are provided to us or videos of empty liquor or prescription bottles. Sometimes it's of the intoxicated person. We've had photos, of a party passed out with children present, for example. There may be apology texts or emails from one party for bad behavior the day before, for example. But with all of this, you must be able to lay a proper foundation for them to come in as evidence at a trial. And so that means whoever is presenting the evidence must have firsthand knowledge and be able to prove that they themselves took the photograph, for example, or the video, and that they received the text, for example, and be able to identify the phone number, so on and so forth. So there are protections in place that try to exclude hearsay and make sure that these are soundly admissible pieces of evidence. So who will testify in this type of proceeding? Usually witnesses with firsthand knowledge are the sort of the first go-to source for the information. This could, generally it's the client who may have observed the alcohol or drug abuse. It could be other family or friends. We've had cases where an old significant other testified on behalf of the other party, testified on behalf of our client. And then also expert witness information. So a forensic or other doctor with experience in treating or examining the alleged drug or alcohol abuser may provide a report and testimony, but they must be specifically qualified to testify in that area of substance abuse. This could also be, testimony that there isn't a significant abuse problem. We've had experts hired to testify to counter other experts, for example. And the private investigator listed at the bottom here is a common person to testify in these types of cases, where you hire someone to follow a person or take photographs of the person, the abuser, the drug or alcohol abuser, using substances, visiting a bar, purchasing liquor, for example. And then that private investigator can testify about what they observed. There's also the business records exception to hearsay. So if you subpoena business records and have them properly certified, these can come into evidence to show purchases of alcohol, for example, on certified credit card statements. Certified itemized receipts or invoices from bars or restaurants can come in. There was a case that I was involved with where I went to a restaurant after a private investigator had indicated that the other party, who we suspected of abuse, had purchased a beer at that restaurant, and he was not supposed to be drinking per the agreements in place in court orders, and then also wine at a dinner with another party present. So we prepared a subpoena, and we asked the restaurant to produce the entire sales receipts from that evening. And it showed that the party had, it showed the absence of the sale of non-alcoholic beer, which the other party had tried to say it wasn't a beer, it was non-alcoholic. Yes, it turned out the restaurant sells non-alcoholic beer, but not any were sold, not one on that particular night. And so we used that to show that he in fact had ingested alcohol that night. Also, all of these properly subpoenaed or certified records can be used in a deposition or introduced at trial in order to try to prove the presence of a problem. And as Maxine Donskoy mentioned, there are, of course, drug and alcohol test results that can be admitted into evidence. Hair follicle, blood, urine results, if properly certified, can come into evidence. Sometimes there must be a foundation that has to be laid for those to come in as well. Alcohol monitoring device records, you're going to hear from Mr. Steve Paymer and Patricia Fersch in just a little bit about monitoring for substance abuse and how that information can be used in a case involving substance abuse. And then also, passing the test may be evidence of compliance. So, if you're willing to, if you maybe have had an issue in the past, or you're willing to show that you don't have an issue, submitting to random testing, may show the other side or relieve the anxiety that you are in compliance, that you are abstaining from alcohol or drugs. And with that, I'm going to turn it over to Patricia Fersch, and she is going to be speaking with our special guest, Steve Paymer.
Hello again. Before I begin with Mr. Paymer, I just wanted to speak about two clients of mine from many, many years ago. And both of them, one had an opioid addiction and the other an alcohol addiction. And both had young children. And they're remarkable for their courage and their willingness to do whatever it took in order for them to be the best mothers. These were both women to their children they could be. And today, each of them is extremely successful in their own right in very different fields, but and their children have done incredibly well with them and in their care and custody. And so it's important to know and to point out that people with problems, when a case might begin, can recover and can be an important part, if not in one instance, the primary parent in their child or children's lives. So I wanted to say that. The other point I just wanted to speak to is oftentimes, and this is true in our area of the country, specifically New York City, we're not really allowed what would be called discovery in a custody case. However, if it's a divorce or if it's a family court case, but there's also a child support proceeding, you may be able to get the financial records as part of discovery in the financial part of the case, vis-a-vis child support or distribution of property. And in that, you can then uncover alcohol purchases that are, in some instances, extraordinary. In one particular case, the mother in that case had literally gone to like 4 or 5 wine stores in her neighborhood because I guess she was embarrassed with the amount she was purchasing on a daily or weekly basis. So she was buying from different wine or alcohol stores. And so that was used in the custody proceedings. So I just wanted to mention that. So now, without further ado, our guest, Mr. Paymer, and his information and his nice picture is up online for all of you. But I'm going to go to now a series of questions. And so, first of all, Steve, are you there?
I am here. Can you hear me okay?
Okay, terrific. All right, excellent. All right, so first of all, if you could tell us a little bit about yourself, your education and background and experiences, and then specifically what your business, Steve Paymer Associates does. What services, if you will, do you provide?
Absolutely, and thank you for having me. Hello, everybody. My name is Stephen Paymer. I'm the owner of Paymer Associates. We are a full-service drug and alcohol testing and monitoring firm. I started in this field about 20 years ago. I have a master's in clinical social work. The business that I'm in now, Paymer Associates, began about 15, 16 years ago. Really because there was a tremendous need for what we do. This field is littered with urban legend. In my experience, I've been doing substance abuse prevention and treatment in one form or another for about 20 years now. And what I noticed early on, immediately prior to beginning the company, is that people think that they have some idea as to what the results of a drug test, of a urine test may mean. But the science is much more involved. And it became apparent to me that a source was needed, particularly in these family cases where livelihoods are at stake, but even more so, children are at stake here. So we seek to provide that. We do every type of testing and monitoring that there is, that's available, with the exception of blood draws, and I'll get into that in a little bit, hopefully. It's very important that there's a single source, that there's a point person involved in these cases who can tell you what the best, there's lots of different ways, as we've seen already, there's lots of different ways to test and to monitor an individual. But how do we put them all together to achieve the objective that we're trying to achieve? What's the best way to do that? One of the wonderful things about these cases that I enjoy so much, particularly as a social worker, is we have a great opportunity here. Most people do not come into an attorney's office, or certainly into my office, on the wings of victory. I'll take a step back and say at this point that I'm also in recovery myself, and I'm very open about that because I feel it's important that people know that there's some place that they can go to get well. But I've been in recovery now for 25 and a half years, and I'm no more virtuous than anybody else. I was simply in enough pain to do something different, to start taking suggestions from people who knew how to live life a day at a time, as we say, without a drink or a drug, and try something new. One of the symptoms of substance use disorder, and this is not in the DSM-5, but we think we know everything and we think we know better. And if we knew, what I said to myself was, if I knew better, I wouldn't be in another rehab bed. So we have a great opportunity at the beginning of these times to not only keep children safe, which is always the primary objective, but to hopefully act as a catalyst towards somebody getting the help that they need.
So Steve, I want to sort of get you on specifics here. So specifically, what services does Paymer Associates, whoops, I cut my head off here. Paymer Associates provide. So what are the services that you provide? And then we'll talk about them if we can.
Again, we do every form of testing effectively that's available. We do urine testing. We do oral fluid testing. We do hair testing. We do, there's something called a drug sweat patch, which can monitor somebody for drugs 24 hours a day, 7 days a week for 2 weeks at a clip. Drugs are eliminated in your sweat as well. So we can do that, and that's what's nice about that is you get 24-hour coverage for any type of drug use. We use a lot of technology when it comes to alcohol. We do remote breath testing, which is basically a handheld remote breath tester with a high resolution camera embedded in it. So every time somebody takes a test, there's a still photo of them as they're blowing into the tube. The image and the breath alcohol content are then sent to whomever we set up in the system to receive the results in real time. So God forbid if somebody who does have an alcohol issue starts drinking while they're the sole custodial parent, somebody is notified and some action can be taken. We also do what's referred to as transdermal alcohol monitoring or continuous alcohol monitoring, which most people know as an alcohol bracelet. They've been in the news every now and then, but that's a bracelet that goes on someone's ankle and takes a reading of the transdermal perspiration or the gas that comes off of all of us, as pleasant as that is, every half an hour.
And when you put all of these tests together, or they're court ordered by an individual, when you're monitoring, what exactly does that mean when you serve as a monitor of someone's testing protocol?
You know, testing really refers to doing a test. Monitoring refers to a longer term program where you're using one or several of these different methods to monitor somebody's abstinence over a period of time. Whatever that period of time may be, it can run from 3 months. We have clients who have been with us for 5 years. When used in conjunction with treatment, monitoring is extremely effective. People who are monitored people who are monitored and receiving treatment for the underlying issue are 6 times more likely to have long-term abstinence than people who are only seeking treatment. So when used as an adjunct to treatment, monitoring is very, very effective.
Now, your company, I believe, you also do substance abuse evaluations. Can you tell us a little bit about what that entails or what that is?
Absolutely. As most are well aware, one of the again, characteristics of substance use disorder is this incredible denial. We like to say we're always the last ones to know what's going on with us. So what an evaluation is it's an interview, usually about 90 minutes, done by a licensed clinician who specializes in substance abuse. And they sort of go through the history with the client as to what issues they may have encountered over the course of their lifetime with drugs and or alcohol. It also includes basically a survey, a very commonly used survey, which will give a clinician a better idea as to whether or not the person is being honest or not when they're answering their questions, because we tend to not tell the truth all the time, especially when we're self-disclosing. So the survey is used for that to see, to give an idea at least as to how honest the individual is being. At the end of the evaluation, the clinician will also speak with any relevant collateral sources, whomever that may be, whether it's a doctor, whether it's the other side, whoever is appropriate, to get some input from them as well. At the end of the eval, there will be a diagnosis, or if there's a lack of a diagnosis, they will state that as well, and what treatment and or monitoring should continue going forward.
Thank you. And what you mentioned denial, and that is often the go-to position of someone who is using and abusing. What happens when someone is in denial about their substance abuse, in your experience?
Yeah, you know, sometimes we could be a little flippant about these things, but denial kills people. Denial is why these things go on year after year after year. And let me be clear that substance abuse is a lifelong disease. We are never cured. We can put it in remission, but it never goes away. You know, sort of the once a pickle, never a cucumber kind of thing. Once you cross that line, we're never better. We're never cured. We get better, but we're never cured. And it's something that has to be addressed on a daily basis. Just as it's the same thing. I mean, a disease is a disease because there's common symptoms, common diagnoses, common prognosis, common treatment. And certainly drug abuse, alcoholism fits that criteria. Denial, we are famous for blaming others, for not being able to see how utterly unmanageable our lives have become. You know, I always say when people are being monitored and they drink while they're being monitored, while their kids are at stake, you know, that's a perfect example of denial. I don't have a problem yet. My children are at stake. I'm being monitored and I still drink. That is an issue.
What about just, and I know this is not an easy question to answer, but what about the duration of monitoring? What's the sort of normal, if you would, if there is a normal period of monitoring someone who has either an alcohol or a drug abuse addiction?
Yeah, I always say that's the hardest question to answer because the odds are stacked against us. I believe at the last I had seen, the odds of recovery are about 1 in 37 the first time that somebody attempts to get clean. So, and yeah, I'm sorry, can you repeat the question? Oh, the duration. That's right. That's right.
The duration. The duration of monitoring. What's sort of the why don't I just say, what's the average that's recommended, if you will?
Yeah, typically, you know, the hope is that somebody will simultaneously be monitored and be involved and invested in their treatment. In those cases, I would say a typical monitoring period probably runs from about 6 months to a year, providing that they're able to remain abstinent during that time. As I said before, we have cases that run for 30 days, and we have cases that are going into their 5th, 6th, 7th year. But the average is certainly, I would say, between 6 months and a year. That's a sufficient time for somebody to build a foundation with the treatment that they've received and be able to take those tools and live a life free of drugs and alcohol.
Let me ask you about, first of all, the age of children impacts on the monitoring, I would think. Is that a fair statement? In other words, the younger the children, the less likely or the less they're able to do anything should their parent become, custodial parent, become, you know, incoherent. So does that impact on the monitoring in your experience, the duration of the monitoring?
Certainly, you know, clearly with infants, with toddlers who cannot simply extricate themselves from a situation or even know enough to make a phone call, we want to make sure that there's some pretty stringent monitoring protocols in place when you have a custodial parent with a substance abuse issue. As they get older, it becomes a little more reasonable to expect, an adolescent to pick up the phone and call the other parent and say, I can't wake mom or dad up. So certainly we always want to take into consideration, where the child or children are at in terms of their development, and it does impact the length of the course of monitoring. Absolutely.
Is there a gold standard of drug and alcohol testing?
I like to say that they're all the gold standard. They all suit a different purpose. The first question I always ask when implementing a protocol, when deciding upon a protocol, is what are we trying to achieve here? And what other services will be in place, and the object of the exercise is to come up with the most time-efficient, cost-effective method of achieving that objective, and simultaneously not becoming such a burden on the person being monitored that it makes their recovery more difficult, because they're constantly trying to accommodate the monitoring protocol. So the science, fortunately, has become superb. We really don't have, I hear about false positives, of course, every day. This has to be, false positives really don't happen. Particularly, the labs that we use, that we contract with, are all accredited. There's federal oversight as to how they're doing their work. We always use chain of custody forensic protocols. So, to ensure everyone's safety. So every case has a different gold standard, if you will.
What about, and this will be the last question, and then we're going to open up to questions. What about these sort of situations where the parent is monitored when the child is in, or children are in their care and custody, and the idea being, go ahead, knock yourself out, use whatever you want when the kids aren't with you? Do you have an opinion about that?
For what my opinion is worth, somebody who, again, with a true substance use disorder, the only thing that I've seen work is abstinence. Again, that sort of speaks to objective. We're trying to just make sure the kids are safe, and that the individual is safe when they're with the kids. If that's the case, then sure, it's an effective means of monitoring somebody. But when looking at the entire clinical picture, it's probably not the way to go. It's been 25 and a half years for me. I still hear from time to time, can't you just have one drink? Well, no. Experience, we know we have a saying about the first drink gets us drunk. It's not the first drink, obviously, that gets us physically intoxicated. But what makes somebody with a substance use disorder who they are is our inability to moderate once we start. Once we press that yummy button, have no idea where it's going to end up. So certainly being able to, when you have a client with a substance use disorder and they're drinking or drugging on the days they don't have the kids, can we try and make sure that they're not, when they're the custodial parent? Sure. But is that going to have a good long-term outcome? Probably not. They'll probably be a repeat client.
Thank you. All right, so we're going to go to the questions. And let's see here. So if one parent has mild or moderate alcohol use disorder, when the child is not in their custody, are they still encouraged to seek treatment and or be tested for alcohol abuse? Well, I'm going to toss this to you, Stephen. Is there such a thing as moderate alcohol use disorder?
There is, in terms of insurance companies and diagnoses and that sort of thing. Certainly. I found that mild alcohol use disorder with time becomes moderate alcohol use disorder, which then becomes heavy, or severe alcohol use disorder. This is, again, a progressive, fatal illness. So certainly, again, and this also speaks to that opportunity that I talked about at the very beginning. Yes, they would want to be treated. Certainly, they would want to be treated.
I'm going to go to the next question. I'll take it. If a parent is ordering large quantities of liquor through the mail, but pays with them on a debit card, is the other parent able to legally retrieve a bank statement to prove that he or she is abusing? So here, a lot depends on if you're married and it's a joint account. Obviously, yes, you're entitled to get all the records of that account. If you are married and it's not a joint account, the records can be asked to be turned over in, again, as mentioned earlier, the financial aspect of a case, if there is one. If the issue is custody and it's in New York City in what would be referred to as the first or second departments, which includes Westchester and Long Island and parts of upstate as well, there you must ask for permission to seek discovery if it's strictly a custody case. And the third answer there is, again, if the parent doesn't turn them over, you certainly can have you would have to have an attorney subpoena the records. The next question I'm going to ask Mr. Kramer, Mr. Paymer, sorry. How do the courts view the use of kratom, I'll spell it K-R-A-T-O-M, a drug that has the same effects of opioids and heroin, but is legal in New York? It's a drug of concern according to the DEA, and the question is direct to you, Steve. Are you familiar with this drug, and is there a way to measure the use of kratom in drug tests?
Yeah, that's a really good question. Yes, kratom in most states is still legal. We don't have a lot of science on kratom. However, they are starting to do a lot more research in it. I wouldn't say that it has the same effect on a person as heroin or other of these strong opioid medications, but they are exploring using it as an opiate replacement drug, such as Suboxone. So when people go into an opiate withdrawal, I have seen them go, move towards kratom, which you can usually get at a corner store, a bodega, for instance. Yes, we can absolutely test for kratom these days in urine, and we can, based on anytime we do a test, if it's positive, it's going to be quantified, which means there's going to be a number associated with it, the amount that was detected in the sample. Based on that, we can have a pretty good idea. It's not an exact science, but we can have a pretty good idea as to whether it's a small, medium, or large amount. But yeah, kratom and the bath salts were another big one. These synthetic sort of drugs, if you will, that have become so prevalent and are legal. I don't know if we have this discussion 5-10 years from now, if that still will be the case. They have not done a lot of research on long-term effects, but it could be a dangerous drug, if you want to call it that, certainly.
There are two questions about, one involving if a parent takes prescribed drugs for chronic insomnia. The question is, does it constitute a potential threat to the child or children on custody days? I mean, the answer here is, what are the effects of the drug on the person? Are they literally in a blackout state where, should the house go on fire, they can't be awakened? That would be a serious issue, and that would impact on their ability to have the children with them overnight by themselves. The other question involves a legal prescription for opioids for pain. We have had this, he wasn't our client, he was our client's actual ex-husband, who had passed out in the middle of the night in the bathroom. His 10-year-old son tried to wake him up, couldn't. The child had the wherewithal to call his mother, mother called 911, and the emergency medical came and took him to the hospital. However, he later said that he was drinking a hard lemonade and had been prescribed opioids for pain. The truth and the reality is that he was using Special K, and so that was discovered later on. I want to go to this particular question is about legal marijuana. So the question is, there's a wide availability of legal edible marijuana and CBD products in most states. If a parent is using recreationally when the child's not in their custody, how does testing apply, since it stays on a hair sample for a longer amount of time and could show that they are abusing? Well, one part of this question is, if they have been ordered not to use anything and are being monitored every day 24/7, then obviously if they take some of this and it shows up, they're violating, what they're being monitored for and a court order. But one of the problems with this particular example is, these look like candies. And we had a case where one of the children was a special needs child who, in addition to having developmental delays, also, liked to eat. And so they weren't secured from the child, and she was able to actually, climb up somewhere and get them. That's a huge problem. If they are not secured properly, you've got a problem in terms of your care and custody. We are going to close it out. We like to do this on time. This recording will be available on our website. All you have to do is click on webinars and then go to the YouTube icon and click on that, and you will see it. It takes us a couple of weeks, so it'll be posted in a couple of weeks. So anyone who missed it or wants to go back and look at the information. Also, as I believe Mr. Duffy told you, all of the slides are available on our Instagram site. We thank you for joining us. We will have the next webinar on January 13th, 2021, which we hope will be a much better year than this one certainly has been. And we are going to, on that webinar, begin the process of delving into financial matters or issues in both a divorce or in child support. And the first topic will be financial affidavits. These are sworn documents that in every child support case and in every divorce must be turned in to the court. We're going to talk about how to complete them, what they should include, and why they are important. So we look forward to seeing you again, we hope, in 2021. We wish you all extremely happy holidays, a very, very happy new year. Please stay safe. Please don't travel. Stay home. And again, Happy New Year and thank you. And thanks to Steve Paymer for joining us here today. We really appreciate him giving us some of his time.
Thank you.